Greetings, everyone. My name is Samantha Teo Chow Yi, and I'm the group leader for Group 14 for the English Legal System assignment. So today, here with me is Nurshifa Nazifa binti Harisham, Kimberly Hodiachi, Emily Madeline Matthias, and Yap Palin. Moving on to the introduction. In the case of Clanwood Benson and Lincoln City Council, Lord Brownie Wilkinson states that, in truth, judges make and change the law. The whole of the common law is judge-made. In this presentation, Shifa and I would be discussing this statement while considering judge-made law under the concept of strict separation of powers and whether judges are merely declarer of the laws. While my teammates Joey, Kim, and Amy would be discussing the concepts of the judge-made law and the factors of development of said law over the years.
Okay, so moving on, I will explain on the what is separation of power. So the doctrine of separation of power requires that the principal institutions of state, executive, legislature, and judiciary, and should be clearly divided into order to the safeguard citizen liberty and guard against the tyranny. So Parliament can make law, and the judge are the declarer of the law who breathe life into the law by applying it. So it also to prevent the concentrations of power on the single body. So the terms of separation of power can also be defined in the strict sense and also in the liberal sense. So in a strict sense, separation of power means that there should be a clear distinctions of function between these three organs of the state, and there should be also a check and balance between these three organs. It should not be overlaps in the function, personals, and power. So in the liberal sense of separation of power means there could be overlaps in the functions and the personals between these three organs, but they also need to be check and balance between these three organs. So moving on is the relationship between the legislative branch and judicial branch. So in a parliament system, legislative assume a private role as the executive is also part of the legislature. So it also can come out of the legislature that remains the responsibles to it and also as a side power of the governments on its behalf. So under the provisions of the constitutions, so the parliament is not sovereign and the judiciary is not a supreme except its own domain. So the parliament and the judiciary come into contact with each other in many ways. So their interrelationship therefore assume a greater significance. So the parliament is expected to keep in the view in the judicial's pronouncements and ruling, so which assume the importance due to the three reasons, which is the first one is the power of the judiciary to interpret the parliament legislature and also give meaning to the word used in the statute to fill in the gaps. And secondly is the judicial power to declare a statute unconstitutionally. And lastly is the times power of the court to invalidate the constitutional amendment. Despite the fact that the legislature and judiciary are kept separate from each other, but both are actually related. So judicials that relate of the legislature, so some legislature of the world have direct judicial power. So the use of Lord, for example, in the highest court of the appeal in the UK. The second one is the judges in some countries can also be removed on the recommendations of the legislature. For example, in India, the judges of the Supreme Court and highest court can be removed from the service by the president on the receipt of an address that passes by the parliament by its two different majority of this effect. The third one is the parliament also hear appeals in the elections cases where they try their members for breach of privilege. So they also may under arrest and try the private citizens for breach of the privilege of the parliaments. So there will be no appeal to the court against such decisions. Next is the legislative that relates to the judiciary. So the judiciary in the modern states in playing a vital role in the process of lawmaking. So the judiciaries added fleshes and blood to the dry bones of law by interpretations and judgment. So the judges also make law by the way of the judicial precedent. So they are established when a novel cases came up before them and no reference is available in the existing body of law regarding that particular cases. So such a judgment become a judgment law or a judicial precedence.
Judges make, find, or merely declare the law. There are two main theories that is relevant to this question, namely the declaratory and the realistic theory. Moving on to the first theory, a view expressed by William Blackstone and was further in accordance with Roger Dworkin is that common law does not change. In each case, the law is merely reinstated but not added to, and the judges are declaring the law on the basis of past decisions. Whereas in the realistic theory, Professor Hart was an advocate for it and stated that he accepted that judges make new law and that this is necessary when there are no existing rules to cover the situation. Another, by Lord Ray, who was a senior lawyer, agreed with this theory by saying, "We do not believe in fairy tales anymore, so we must accept the fact that for better or worse, judges do make law." An example is in the case of Donahue and Stevenson, where Hart could see that it was a new law being made that a manufacturer is liable to the consumer for defective product, which filled a gap in the existing principle that people had a duty to not harm others and extending it to a new situation. And in modern times, there is a strong prejudice against judges making law. This is because it is tantamount to say that if a judge feels he or she decision is more valid than the legislation, it is making the legislative branch somewhat redundant. In addition, the declaratory theory also faces many criticisms, one of which it does not reflect the reality of how law is practiced, and historically it is also clear that a large areas of contract and tort law are developed by the courts and not by parliament. So in conclusion, judges do make law, and we must keep in mind that the laws do change as new situations abound, and based on the realistic theory, it has to be accepted that judges do indeed make new law and that this is necessary when no existing rules cover a certain situation. Next slide. When or the occasions for judges to make law. So first is the interpretation. Most of the time, Parliament is unable to define each and every possibility or explain every term in a statute, and hence arises a need for judges to interpret the law and apply it to the case before the court. So an example can be seen in the case of DPP and Jones, which concerned a demonstration on the road near Stonehenge. In this case, the Lords look at the rule that the public have the full right to use the highway for purposes like walking, passing, and repassing as uses related to it, but not demonstrating and picketing. In Jones, the House of Lords stated that the rule levied unrealistic and unwarranted restrictions on everyday activities, and that the highway is for public and public has the full right to use the highway for reasonable purposes. And the next one is the lacuna in the law. This situation may arise in which there is no express law. This can be seen in the case of R and Dicta, which is a criminal case, and the Court of Appeal overruled an earlier case of R and Clarence in 1888 and held that the criminal liability could be imposed on the defendant for infecting another person with HIV. This change in the law has made irrespective of the fact that the Home Office had earlier decided that such a legislation should not be introduced, which would impose liability in this situation. The Home Office observed that this was a case of social and public health policy. Considering the case of R and Dika, this case illustrates that the convict was sentenced to a 4.5-year imprisonment, which was not sufficient for the offence which was committed. The complainant was inflicted with bodily harmful HIV through sexual intercourse with the applicant. The applicant sought leave to appeal against the office on inflicting. He did so that the original decision of the Court of Appeal could reconsider in House of Lords, but the appeal was dismissed because the Court of Appeal was bound by its own decision of similar cases. Therefore, the leave to appeal to the House of Lords was refused. And the last one is common law. There are many areas where statutes don't exist, in which judgments in existing cases are heavily influenced by previous cases. An example could be seen in Chelmsford, Benson, and Lincoln City Council. So this case illustrates about the rule which existed for nearly 2.5 centuries that if the payments were made by mistake, they did not have the right to get the money back. In this, the judge held that he was bound by the restrictions of the rules that money paid under mistake of the law was not recoverable. The plaintiff was appealed for the recovery of money. Allowing the appeals, Lord Brunny Wilkinson and Lord Roy dissenting that the law should not be practiced anymore, and it should be changed so that the money can be recovered by the plaintiff. Therefore, the change in the law is desirable, but it should be left to the Law Commission and Parliament such that the new course of action can be introduced.
Okay, so how judge made law? So judges can and do create a new law while talking about the judges' roles during the creations of law while take place, especially in two fields, which is in the developments of the common law, and the second one is interpretation of statutes. So basically, their freedoms is restricted by the rules of precedence and the supremacy of Parliament, and by the rules of precedent and the rules of the statutory interpretation. So the court cannot move out of their shoes of the legislature and make decisions or create law, but they have to be confined to their territories, and the guidelines that are given by them is to be followed until the legislature step into to make law. So there has been some the means under which the law is created, like height and low parameters. So judicial activism should not become the judicial adventurism and lead a judge's going in the pursuit of his notions of justice, ignoring the limits of the law. So the court must be in confidence in the giving the effects of constitutions and recognitions of the right of the individuals that giving effect to a more meaningful life and the others. So the common law, the law made and development by court is known as the common law. So individuals are able to contribute to the developments of common law by bringing a matter to the court to settle an issue. So as we know, the common law is made when a situation that come before the court for which there is no existing legislations or situations that existing in the common law. So when the judges make a decision on the cases, they create a precedent which must be followed in the future. Last one is the statutory interpretation. So judges also establish the precedents when interpreting statute. So they will be interpret statute when there is dispute about the intentions of meaning of the word in the statute. So therefore, by conducting statutory interpretations, they will clarify the meaning of certain law. For example, one of the statutory that interpretation that can be found in the cases of Dean Carola. So that's all from me.
Hi, my name is Amy. Today we're talking about common law. Common law is a body of law based on case law and legal precedents to guide their decisions. It is also legal principles known as stare decisis. It emphasizes precedents while allowing some freedom for interpretation. The value of a common law system is that the law can be adapted to situations that were not contemplated at the time by the legislature. Origins of common law. Common law was developed during Norman conquest by William the Conqueror to establish a central government. This is because before the common law, people were governed by unwritten custom rules which are mostly orally transmitted. In creating a centralized government, common custom around England were consolidated and complied to form common law. English common law system is referred to as a traditional, mystery, particularistic, and growing organically. This is because English common law is derived from judges' interpretive choice and is subject to changes, uncertainties, and modifications. Other than that, the common law of England is a product of 100 years of development that grew to a multitude of judicial decisions. The first common law is also used to denote the law applied by the court as developed through the legal system of precedents without reference to legislations passed by the parliament. Besides, the common law resides in judicial decisions rather than the rules. It is because only in the late 19th century that the statutes become available in England and Wales, and the understanding is the most of the law was applied to the court independent of any statutory source. Other than that, common law traditions have always emphasized judicial independence. They are often judgment law, which is seen as important elements, as judges will address contemporary issues that may not come in the mind of the legislature. According to the Blackstone, judges are living oracles that must decide all of the cases of doubt. In other words, a judge is seen as a spokesman of the community about its law. The common law system is seen as the law that found in individual judgments as rule of set precedents and are developed on a case-to-case basis. Next, the common law system derived inductive reasonings where the legal principles are derived from the individual judgments on case-to-case basis. As we can see from Donohood versus Stevenson, where the Lord and King developed the neighborhood principles. Lastly, the common law is a seamless web. This is where the law will always provide an answer even if you do not find it immediately. And the participant of judges in a common law jurisdictions is also passive. It allows counsel to exhibit an adversarial nature. What is judgment law? Stare decisis. Stare decisis is a Latin phrase which means let the decision stand. The system of stare decisis is sometimes referred as a judgment law. This is because it was created by the judges, not by the legislature. In the case of Castle versus Broom, Lord Red Elsie said, "The fact is, and I hope it will never necessary to say so again, that in the hierarchical system of court which exists in this country, it is necessary for each lower tiers, including the Court of Appeal, to accept loyalty to the decisions of higher tiers." Types of precedents. There are two types of precedent, which is the binding precedents and the persuasive precedents. Binding precedence is a precedence that a court must abide by in its adjudications of a case. For example, a lower court is bound by the decisions of a higher court in the same jurisdictions, even if the lower court judge disagree with the reasoning or outcome of the decisions. While for the persuasive precedent is a precedence that a court may but is not required to rely in deciding a case. For example, decisions from courts in neighboring jurisdictions and dicta in the decisions by a higher court. Case law. As opposed to law based on constitutions, legislations, or regulations, case law is a law that is based on court decisions. Case law relates to particular conflicts that are solved by the court based on demonstrable fact in a case. Judicial precedents. The judicial precedents must have a clear hierarchy of court. At the lower end of the hierarchy are the magistrate, Crown and County Court, where these courts do not have the power to create or overrule precedent set in previous case. The upper end of the hierarchy is the Appellate Court, which is the High Court and Court of Appeal. At the very top are the UK Supreme Court, where these courts do have the powers to make the precedents and in some cases depart from them. Of the judgment law. There are four principles. First principle is a judge must follow a judgment that has already been rendered by a higher court or in certain situations by a court at the same level on the applications of the law to make a comparable set of facts when making a decisions in a case. In this sense, the court precedent is considered to be the binding on the judge. Second principle is a judge may rely on prior ruling from a lower court even in a certain circumstances, a foreign court, but they are not required to do so. This is also known as a persuasive precedent. Third principle is a judge is not bound to follow the decisions in an earlier case if the facts are distinguishable. Last principle is a court higher in the judicial hierarchy disagree with how the law was implemented in the previous case. It may overturn a precedent set by a court lower in the hierarchy. That's all from me. Thank you.
Hi, my name is Kimberly, and I will be presenting the advantages and disadvantages of common law, or in other words, the judgment law. And I will start off with the advantages of common law. Firstly, because the judges are unelected, it is believed that they can take unpopular position when necessary to protect human rights. This can be seen in the case of Liversidge and Anderson by House of Lords. What happened in this case was that Sir John Anderson, who was the Home Secretary at that time, relied on the Regulation 18B of the Defense General Regulations 1939, in which the Secretary of State was permitted to make an order against the person directing that he be detained if he has reasonable cause to believe any person to be of hostile origin or associations. And Anderson detained the claimant, placing him in prison with no reason why. Lord Atkin, in his dissenting judgment, said that the courts should ensure that the executive did not overstep the boundaries between the executive and judiciary. Besides, the common law provides a degree of certainty, as the judicial precedents say that like cases will be treated alike. This helps people to plan their affairs because there may be one case in the past where the facts are similar and the decision is in favor of them. Moreover, common law is said to be more flexible as the courts may respond more quickly than the parliament because the law needs to be flexible to meet the needs of a changing society. In the case of R&R 1991, the House of Lords decided that marital rape was illegal as the society had been changed, and the Sir Matthew Hill's law, drafted in 1700, which said that upon marriage the wife has surrendered all her consent to her husband, was not applicable. And the last advantage would be detailed practical rules provided by the common law. This is meant by the nature of the case law, which is a response to real situations, unlike the statutes, which are more based on theory and logic. There are also several disadvantages of the common law, and I'll start with the complexity and volume, because as we know, the judgments are normally very lengthy and it's very difficult to pinpoint the appropriate principles. And for this, the case law made has the retrospective effect, which means that the changes made by case law apply to events which happened before the case came to court, unlike legislation, which usually only applies to events after it comes into force. And the next one, as the judges are presented with the facts of the case and the legal arguments, the only task is to decide the decision of the case. Theoretically, they are not concerned with social and economic implications, so they cannot carry out research or consult experts, while Parliament can do this during the lawmaking process. Besides, for the undemocratic elements, as the judges are unelected, there are some people questioning whether the judges should have the freedoms to decide cases on grounds of political and social policy. And for this, what is meant by this rigid is that the judicial precedent mentions that judges should follow a binding precedent even where they think the law is not appropriate. This means that this bad law may stay for a long time before a court high enough has the power to overrule this. And the next one is the dependence on chance, because only a few real-life disputes are brought to the court, and among these, lesser cases will reach the higher appeal court. So the case law only changes in response to those cases brought before it. And the progression of the common law is unsystematic because it develops based on facts rather than comprehensive code. And sometimes a whole series of rules can be built on one case. And if the case is overruled, this whole structure will collapse. Lastly, due to the fact that the binding precedents must be followed unless the facts are largely different, the judges tend to make small distinction between the facts so that they can differentiate the precedents. This will create a mass of cases all establishing different precedents in very similar situations, like a small difference in the facts. This further complicates the law. And the certainty mentioned, as I mentioned before, will be lost as too many of these small distinctions. It is impossible to figure out which precedent will be applied. And that's all from me. And next will be Pei Ling, who will discuss further about common law.
Hi, I am Yapelin, and I'm now going to discuss the factors that led to the development of judge-made law over the years. The first factor is the influence of Blackstone. Sir William Blackstone is the most famous English jurist. He was the first person to lecture on English law at English University. The Commentaries of the Law England was published by him between 1765 and 1769 and consisted 4 books. The first book is Of the Rights of Person, which deals with the family and public law. The second book is Of the Right of Things. This book gave a brilliant outline of real property law. And the third book is Of Private Wrongs, that covered civil liability, courts and procedure. And the fourth book is Of Public Wrong, and it was an excellent study of criminal law. Blackstone was far from being a scientific jurist and was criticized for his superficiality and lack of historical sense. The shortcomings, the commentaries, were offset by its stalls and intelligibility, and lawyers and laymen alike came to regard it as an authoritative exposition of the law. After the American Declaration of Independence 1776, the commentaries became the chief source of knowledge of English law in the New World. The second factor is the reforms since 19th century. Following the French Revolution and the Industrial Revolution, there were many demands for reforms to modernize the law. The most significant figure in the reform movement was the English philosopher Jeremy Bentham, who was prepared to reform the whole law along radical lines. In 1769, he entered the bar, but since he was living on inheritance, he never found it necessary to enter practice. He worked to make law less technical and more accessible to the person, but he was slow to complete or publish his writing. Bentham attacked legal fictions and other historical anomalies. He advocated two basic changes in the legal system. His practical influence was far more indirect and derived largely from the diffusion of utilitarian ideas during 19th century. Moving to the change in procedure and criminal law. In England, the old framework of the separate forms of action in civil case was replaced in 1855 by a new system of uniform writs of summons, and liberal amendment of pleadings was permitted. A series of evidence acts simplified civil proof. Far-reaching reforms of the civil procedure were introduced in the year of 2000 as a result of a report by a judge, Lord Wolf, who was appointed Lord Chief Justice to implement the changes called for in his report. This principally consisted in simplifying procedure, but the language was also altered. A major trend in criminal procedure since the early 19th century has been better protection of the rights of the accused. In the year of 1907, the right of appeal against criminal conviction was created. Further change to criminal procedure have frequently been discussed, including the restriction of jury trial to certain types of cases. Furthermore, it is the reorganization of the court. The jurisdiction of the church courts over the laity ended in 1857 when secular divorce and probate courts were set up. The judicial acts were much more than a regrouping and renaming of court. They attempted to fuse law and equity by making available legal and equitable remedies in all divisions of the high courts and by providing that the equitable rule should prevail when conflicts arose. In the late 19th century, the three central courts of common law were amalgamated as the Queen's Bench divisions, which to this day continues to try suits for damages. Since 1875, cases have been tried by a single judge, sometimes with a jury, not by a full bench of judges. After it became a division of the High Court in 1875, the Chancery not only dealt with equity suits, but also administered the voluminous legislation on these certain issues. A remarkable feature of English criminal justice, as compared with most European systems, has been the continuing role of lay magistrates, who remain important despite the appointment of paid legally trained magistrates, now known as district judges, in London and some of the larger cities. Those developments since 1948 show both of the persistence in English law of ancient institutions and a preference for reforming rather than totally abolishing them. A final appeal, subject to conditions, can be made to the Supreme Court, which should replace the House of Lords as a court of final resort by the Constitutional Reform Act 2005. Now I'm talking about the cases that contribute to the development of law. The first well-known case is the case of Donahue and Stevenson's 1932. It could be interpreted as narrow as to establish a duty not to sell or pack bottles of ginger beer. The primary outcome of this case is the further development of the labor principle by Lord Atkin. The case of Donahue was just a milestone in a new principle which need refining. As Lord Reid said, it will require qualification in new circumstances. The second case is the case of R&R 1991. The defendant was charged with attempted rape under Section 1 Sub 1 or the Sexual Offences Amendment Act 1976 and with assault occasioning actual bodily harm under Section 47 Offences Against that Person Act 1861. The law is constantly evolving to meet changing social attitudes. In this case, the House of Lords swept away the common law rule that a man would not be guilty of raping his wife. The House of Lords ruled that for modern times, marriage is a partnership of equals and any other suggestion was quite unacceptable. This is all from our group today. Thank you for listening.